The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Morning, everyone. Next case is State versus Alston, and we'll hear from the appellant.
Oh, Mr. Edgerton, you're muted.
Is it correct now? Okay. May it please the court. My name is Jarvis Edgerton, and I represent defendant appellate John Alston. I hope to reserve 15 minutes of my time for rebuttal. Before I get off track and ramble due to nervousness, I'd like to list the key points I hope to make. As to the law, the majority here applied it in two crucial ways. First, it failed to consider evidence that contradicted its holding. This was in violation of this court's holding in State v. Lattimore that instructs justices reviewing these issues to consider the full totality of the record in all the circumstances. The Court of Appeals majority did not do that. Second, it failed to ever ask the actual question presented as set forth in this court's cases of State v. Blackstock and State v. Yellow Bay. These cases are in the majority opinion standard of review, and I will address that in more detail. As to the facts, the majority omitted from its consideration evidence that the trial court told the jury that, quote, but the facts of this case have demonstrated that there was actual contact. There was a touching of some form that is non-consensual and unwanted by the other party, end of quote. Additionally, as to the facts, this case stands out from all the other cases addressing this issue by virtue of repetition. There were 5 separate instances over the course of 2 days where the trial court expressed an opinion that an assault occurred. That no other case has that kind of, that I've reviewed so far, has that kind of repetition of a expression of opinion error. So that makes this case uniquely prejudicial. Second, and the heart of this goes to the heart of the case. As some of the case law talks about, that makes it more prejudicial. It goes to the heart of the case. The existence of an assault is an element of the offense. It doesn't get any more to the heart of the case than that in this instance. And fourth, the evidence of the trial was weak. I get into this in the brief, and I hope to get into it a little bit here, but I just wanted to make sure I make that point right now.
Counsel, before you get too deeply into the substance of your presentation, I wanted to ask from the very beginning so that we could focus properly. Why is it that you contend that this is de novo review as opposed to the state's contention that this is plain error review?
Because the Court of Appeals majority and dissent both agreed that this was normal appellate review as a statutory mandate. It's right and center in the majority opinion, and it's the same standard of review used in the dissent. The state's claims about plain error are not before this court. This case is here pursuant to the dissent, and there was no disagreement in the Court of Appeals that the standard of review was normal review pursuant to State v. Ash and a statutory mandate.
I mean, Mr. Edgerton, in looking at this, it seems that, it looks as if this court stated in 360 in State versus Dukes, which is 360 NC 110, that, quote, whenever a defendant alleges a trial court made an improper statement by expressing an opinion on the evidence in violation of GS 15A, 1222, and 1232, the error is preserved for review without objection due to the mandatory nature of these statutory prohibitions. And that appears at page 123, I think. Is that your understanding of what the applicable standard of review is here?
No, not at all. First of all, I repeat that this question is not before this court. This is here pursuant to the dissent, and the majority very clearly said on page 6 of its slip opinion. Let me find it real quick.
I thought the material that I just read, the statement that I just read to you, indicated that it was fully preserved without objection, and therefore that the normal standard of review would apply despite the action.
Yes, I'm sorry. I misunderstood you then. If I'm just to clarify this, on page 5 of the majority opinion, The majority cites State v. Ash and acknowledges that this is a statutory mandate case. And obviously the dissent didn't disagree with that. So I believe for multiple reasons, this is here for normal appellate review as a statutory mandate. And there's a case that expressly says that this statute is reviewed under that standard of review. And if I can find it, I can get it to you later or bring it up later. But again, I repeat that this question is not before this court.
While we're talking about standard of review, it's not clear to me what your position is on whether any error that the trial court committed, get to whether that happened or not, is subject to any kind of prejudice analysis. In your opinion, is it?
You know, that is unclear. That is a very good question that I'm not exactly clear on the answer to. Let me read from the law and the majority opinion here. Citing State v. In State v. Blackstock, citing State v. Yellerday, the rule for review appears to be, thus in a criminal case, it is only when the jury may reasonably infer from the evidence before it that the trial judge's action, in this case, saying repeatedly, implying and in fact saying that an assault has occurred, the trial judge's action intimated an opinion as to a factual issue. The defendant's guilt, the weight of the evidence, or the witness's credibility, that prejudicial error results. This statement seems to suggest if these conditions are met, it's prejudicial error. And I believe that is the correct statement of the law, seeing as how it's set forth in multiple North Carolina Supreme Court cases, including Yellerday and Blackstock, which appear in the standard of review section of the majority opinion. I would say from that language that if this court establishes, it finds that the jury may reasonably infer that the court expressed an opinion, that's prejudicial error and it's reversible.
So your argument then is that assuming that you have an impermissible expression of opinion, that by itself necessitates a new trial in this instance?
Yes, and the reason for that is
essentially then you're contending for per se.
Yes, and I'm prepared to argue both, but I contend it's per se. And the reason for that, the logic behind that is when the trial court in its exalted station expresses an opinion, that's going to weigh on the jury verdict. You can't measure how much that weighed. You can't quantify it and then argue it as prejudice. You just have to apply common sense and know that this has created a potential for a severe prejudice to the defendant, and we just can't allow it. It is not. You look through these cases, and it's the firmness with which this rule is stated is strong. This cannot be allowed. A judge may not express an opinion as the guilt, may not express an opinion. It's an expression of judicial leaning is absolutely prohibited, regardless of the manner in which it is expressed. That's from State v. Atkinson. All these cases have that kind of language. Now, admittedly, there's parts where they say not every instance merits reversible error, but if you look at the cases where they talk about that, they find that it's not an opinion. They still apply the proper rule here, but they don't conclude it happened, but it wasn't prejudicial. They conclude it didn't happen.
So your contention then is that regardless of the strength of the evidence against a particular defendant, there's never any set of circumstances under which the evidence can be so overwhelming as to support a finding of.
Yes, the mere fact that the trial court expresses an opinion taints the verdict. Ab initio. That is my position.
So we don't need to worry about reasonable possibility, reasonable probability, or anything of that nature.
No, I would say y'all don't. I do, though. I'm going to make the argument that if y'all find otherwise, it's still blatantly obvious prejudicial error in this case. But my position is that y'all don't have to get to that point. That the sanctity of the trial of the jury relying on its evidence and not being tainted by statements from the trial court is too important to be minimized with some sort of prejudicial error review. If the trial judge did it, that's it. It's new trial. We can't trust this verdict. And I believe that's the rule, and I believe that's a rule that makes perfect sense if we care about fair trials. This is not the kind of chance you want to take.
All right, thank you.
And if I may say, I do argue prejudice in the Court of Appeals brief and the North Carolina Supreme Court brief, even though I don't agree that this court has to get to that. And so I want to make sure that y'all understand there is a prejudice argument here. Okay, thank you. That's a good question, and that dovetails right into some of my script. So I'd like to start with the undisputed facts in this case. Both the majority and minority opinions cite to 4 instances where the trial court plainly intimated to the jury, while instructing the jury on the charge of assault on a female, that it believed an assault occurred. Reading from page 9 and 10 of the majority slip opinion, the trial court told the jury, quote, "You will determine what the assault was, ladies and gentlemen," end of quote. 3 sentences later, the trial court repeated itself, saying, "You will determine what the assault was." 2 sentences after that, the trial court explained, while it's not telling the jury what the assault was, it instructed the jury, quote, "You should rely on your recollection of the evidence as to what the assault is that has been testified to in this case." During re-instruction the next day, the trial court instructed the jury that it is alleged that she, the prosecuting witness, was hit about her body multiple times, whatever part of the body that may be, head, face, torso, arms, legs, that will be for you to decide. Those are all the instances that the majority and dissent cite. In addition to these 4 instances, the dissent cites a 5th instance that occurred during the re-instruction trial on day 2, when the trial court instructed the jury, quote, "But the facts of this case have demonstrated that there was actual contact. There was a touching of some form that is non-consensual and unwanted by the party." That's clearly an expression of opinion about a fact. This quote comes from page 3 of the dissent and the slip opinion. Defendant notes that in the block quotes included in the majority opinion, the paragraph where this came from is included. But if you look at the majority opinion, this quote is omitted and replaced with ... This omission from its opinion of what is arguably the most blatant example of the trial court's repeated violations of 15A-1222 and 15A-1232 is strong evidence suggesting the majority did not properly consider the totality of the circumstances as required by this court's holding in Larimore. Moreover, the particular evidence the majority omitted from consideration here is indispensable to the proper evaluation of this case on the merits. These significant flaws undermine the persuasive value of the majority opinion. They simply didn't follow the law. And they didn't follow the law in a very crucial way here. Now, getting to the standard of review. We briefly discussed this. In addition to failing... Yes.
Before you move to the standard review, talking about the totality of the circumstances and reading the jury instruction as a whole, the state argues that the trial court also, at least a couple of times, said to the jury, it's not my recollection, it's not my statement of the facts that matters, you're the one to determine. And I think that happened when the trial court issued its instructions initially and when it came back the second time and was instructing on the elements of the offense in response to the jury's question. And so what are we to make of the fact that in other parts of the jury instruction, the judge made clear that it was the jury to decide the facts?
That is irrelevant. The question before this court is whether the jury could reasonably infer that the trial court has expressed an opinion. These are apples. What has happened here is the majority opinion is a little game of apples and oranges here. The question before this court was the question set out in Blackstock and Yellerday. And if I may, that was exactly the next point I was getting to. If I may run through here. In addition to failing to show the totality of the circumstances, the trial court also failed to follow the guidance this court set out in Yellerday and Blackstock for expressions of opinion error. Both these cases are cited by the majority. Pursuant to these cases, the standard of review for improper judicial expression of opinion claims is, quote, whether the jury may reasonably infer from the evidence before it that the trial judge's action intimated an opinion as to a factual issue. It's not talking about whether the trial judge issued a directed verdict. Defendant did not raise a constitutional claim here that he was deprived of his right to a trial by jury. That is not what we're talking about. And this standard the court uses is based on a misinterpretation of State v. Young. And the dissent does a very good job of pointing out why the majority's reliance on State v. Young is flawed. But as a result of that misunderstanding by the majority of what the question was, the majority comes out with a holding that's essentially irrelevant. This is the majority holding here. Quote, upon review of the record and the totality of the circumstances, we hold that the trial court's instructions to the jury made clear that the determination of whether the evidence showed defendant had committed an assault upon Claudette was left entirely to the jury. Basically, my response to that is, so what? That's not the question. The question here is whether the jury may reasonably infer from the evidence before it that the trial judge's action intimated an opinion as to a factual issue. The answer to that question is yes. And the answer to the other question is irrelevant.
Mr. Edgerton, I'm sorry, let me make sure I understand. Are you saying the totality of the circumstances in our review is or is not relevant?
The totality of the circumstances is relevant. What I'm saying is the trial court asked the wrong question.
Okay, I'm sorry, let me follow up.
The appellate court.
If the totality of the circumstances is relevant, then why are the judge's proper instructions to the jury not to be considered?
I'm not saying that you should not consider, I'm not saying that that should not be considered. I'm saying that these things that the court is talking about do not address the question presented. It does not matter. I am not raising a directed verdict claim. I am not saying the trial judge demanded that the jury see things its way. I'm saying that the trial judge told the jury what it thought. That's the question here. Did the trial court express an opinion that the jury made the jury reasonably infer from the evidence before it that the trial court expressed an opinion as to whether an assault occurred? The question before us is not whether the trial court told the jury it had to find this. The question is whether it expressed an opinion. And if you look through the cases where they talk about the exalted station of the trial court, that's the problem. When the trial court expresses an opinion, even if it says it's up to you to decide the facts, when the trial court expresses an opinion, that opinion is going to carry weight in the jury room. And it's going to influence the jury's decision on what the facts are. And I know this distinction is not necessary. I'm not explaining this well, but this is a crucial distinction here. The majority opinion is fatally flawed because it never asked the right question. So,
hopefully, Mr. Edgerton, I'm asking the right question, at least for me to understand where you are. Is it your opinion that once the trial court expresses an improper opinion, that can never be cured?
It can be cured if the trial court says things that later negate that improper opinion.
And why were the instructions that the trial court gave here insufficient to cure the problem with the improper opinion?
Because nowhere in those instructions does the trial court say, I misspoke when I said 5 times, when I said statements 5 times that clearly indicate that I have an opinion. The trial court never withdraws its opinion. It simply says, oh, just it's up to you to find the facts. Never mind that I told you that me, the trial judge who's been doing this for a long time, clearly believes that the facts support this opinion. It's up to you to decide. And if I may,
thank you, sir.
I have a hypothetical to illustrate this. Suppose the trial court had said, I am convinced that the evidence shows that an assault occurred. However, it's entirely up to you, members of a jury, to decide if the assault occurred. If we follow this court's guidance from Blackstock and Yellerday, the first sentence of this hypothetical is determinative. Plainly, when a trial court in an assault on a female case says it's convinced that the evidence shows an assault occurred, the jury may reasonably infer the trial court expressed an opinion as to a factual issue. Under Blackstock and Yellerday framework, it doesn't matter that the trial court also tells the jury that the elements are for it to decide. the jury could still reasonably infer that the trial court intimated an opinion as to a factual issue, and that would carry weight in the jury room. That's the harm here. If we follow the Alston majority framework, however, the second sentence of the hypothetical is determinative. Regardless of how strongly or clearly the trial court intimated an opinion on a contested factual issue, so long as the trial court does not go so far as to actually usurp the fact-finding role of the jury, under the Alston framework, it's not error what it said. And
Mr. Edgerton, Mr. Edgerton, two things. I didn't record if you asked for time for rebuttal. Sorry.
And if I could stop here, I'd love to save the time I have left for rebuttal.
Well, I'll get you to answer my question first.
Okay.
You can save it.
Okay.
So my question comes from Blackstock. In the first paragraph or second paragraph of the opinion, it says, even so, every such impropriety by the trial judge does not result in prejudicial error. Whether the judge's comments, questions, or actions constitute reversible error is a question to be considered in light of the factors and circumstances disclosed by the record, the burden of showing prejudice being upon the defendant. Two parts to the question. One is, how is that statement in and of itself not a, how does that not undermine your view that this is a per se or structural error, since it says that the burden of showing prejudice is upon the defendant? And the second part of that is, assuming that we do say that there is a prejudice analysis, what in this record can you point to show us that this was prejudicial?
The answer to that first question is, I agree that the law here is confusing and conflicting on that issue. That's why I made a point of arguing prejudicial error, because
I don't know that you would be agreeing, because I'm not saying it's confusing.
I think it's confusing. And I certainly agree that there are other cases that seem to suggest that there's a prejudice analysis here. So, and that dovetails to the last points I want to make. Why is this prejudicial? Repetition, 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 repetition. There are at least 5 instances in this record over 2 days of the trial court making statements that clearly indicate to the jury it has an opinion about whether an assault occurred. On top of that, the opinion expressed by the trial court goes directly to the crucial element of the charged offense. It doesn't get any more to the heart of the case than it does in this case. You will never find an example where it's more to the heart of the case. It simply can't be more to the heart of the case than it is here. And I might find my words.
Yeah, so again, my question is, what evidence is there in this record that no assault occurred?
Well, the defendant's not guilty plea. The burden is on the state to prove whether an assault occurred. Now, I understand you're getting into this idea that the trial court is just simply describing the evidence from the case, from the trial. There's an analysis like that, but that's not what is going on here. The trial court very clearly indicated that it believed an assault occurred. And while I am arguing that, I'm not arguing that this is a deprivation of the constitutional right to jury, I do think that it's pretty clear, if you look at the totality of this record, that the jury may reasonably infer that the trial court expressed an opinion. And going to all the exalted station law that you see in these cases, that matters. That matters a great deal. When the jury looks at the evidence and sees that no law enforcement officer testified, that essentially the only person making fact claims is the prosecuting witness, who's in a domestic relationship with the defendant, and only has some pictures taken after the fact as in support. We're talking about a he said, she said case here. And an important factor the jury may also consider is the evidence was that law enforcement took pictures too, but did not tender them at trial. The pretty clear implication a juror may draw from that fact is that the law enforcement considered the pictures it took, the objective law enforcement officers took, don't further the case. I addressed this in my briefs. this is not an overwhelming evidence case at all. This is a very, very weak case the state put forth. And within the trial, there are plenty of reasons for the jury to infer that law enforcement was not fully behind this. They gathered evidence that they chose not to present, and no law enforcement officer testified. This was an extraordinarily weak case, and I'd like to save the rest of my time and refer the justices to the prejudice arguments in the brief in support of that. Oh, and I also say, you better remember the trial court said a non-consensual touching occurred here. It's hard to look at this record and say that there's not strong evidence of the trial court expressed an opinion, and it's hard to say that that evidence is given the full context, that evidence is not a serious danger of having influenced the jury verdict here. I reserve the rest of my time.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Chris Augusto Carrero, representing the appellee in this case, the state of North Carolina. The issue before this honorable court is whether the Court of Appeals correctly held that the trial court committed no error, that is, expressed no improper opinion during its jury instructions. The state asks this court to affirm the Court of Opinions decision for 3 reasons. First, under the plain error review and applying totality of the circumstances, the trial court did not express an improper opinion.
Ms. Augusto, before we go any further, I know you cited one case that contains a reference to plain error, but isn't this court's most recent discussion of whether the standard of review for expressions of opinion, our discussion in Dukes that I read to Mr. Edgerton, which says that it's preserved without objection?
Your Honor, this honorable court and the Court of Appeals both recognize that when you're discussing whether an improper opinion has occurred, that analysis is preserved for appellate review. However, it is not preserved as a de novo review. And that is what the state is contending. The state is contending that while the defendant did not object to the jury instructions at trial, it may still be reviewed. However, the correct standard of review is plain error.
Isn't plain error review only applicable when the alleged error is not properly preserved for review?
It is, Your Honor. And Your Honor,
how does plain error have anything to do with something that's properly preserved by statute?
Your Honor, the reason the standard of review and the appropriate one is plain error is because this honorable court in State v. Odom, which was in 1983, adopted the Fourth Circuit plain error review standard specifically in this case.
Was Odom an improper expression of opinion case?
Yes, Your Honor. In State v. Odom, the court said that even though the defendant had failed to object, but in order to avoid the harshness of Rule 10b-2, that the plain error review would be applied, and that it is a high fundamental bar. The error has to be so prejudicial, so lacking in justice, that the instructional mistake had a probable impact on the jury's verdict.
To your recollection, was the instructional error that was at issue in Odom one involving an allegation that the trial court expressed an opinion?
I remember, Your Honor, that in State v. Odom, it had to do with an instructional error during the jury instructions, and that decision was in 1983. However, State v. Larimore, which defendant alluded to, that was in 1995, and State v. Larimore was decided, was centered around whether an improper expression was made, an improper opinion. And when you look at State v. Larimore, the court was considering whether the jury could infer that the court preferred the state witnesses over defendant's witnesses because of an improper comment that the judge made. And in that case, this court said, we cannot find The comments rise to the level of error and do not constitute plain error. So in State v. Larimore, this court clearly was reviewing under plain error standard.
Well, what do you make of State versus Dukes then, or are you familiar with it?
I'm not precisely familiar, Your Honor. What specifically in that case are you referring to?
Well, there's the statement at page 1, which read it to your colleague. It is the statement the case appears at 360 NC 110. The statement is at page 123, and it says, quote, whenever a defendant challenges a trial court made an improper statement by expressing an opinion on the evidence in violation of GS 15A 1222 and 15A 1232, the error is preserved for review without objection due to the mandatory nature of these statutory prohibitions. And it cites State versus Young, which is at 324 NC 489.
Yes, Your Honor. However, if I remember correctly, it then goes on to state that not every improper expression would lead to a reversal. That indicates, Your Honor, that it's not just a de novo review. The court is looking first whether there was an error, and then second, was it a prejudicial error? Was it lacking in such fundamental justice that it would result in overturning a conviction? And that's why, Your Honor, again.
And in your view, those things equate to plain error?
Your Honor, there is a distinction between plain error and prejudicial error. In plain error, you're looking at whether there was a probable impact on the jury's verdict. In looking at prejudicial error, it's whether there was a possible impact on the jury's verdict. In either situation, Your Honor, the state contends that there was no error. And to the extent this honorable court were to find error, it is not to the level of plain or prejudicial error. And so the standard of review is not de novo, it is plain error. And if this court were to find that it's actually prejudicial error, it still doesn't rise to that level. For those reasons, Your Honor, that's the state contends that the standard of review, the appropriate one, is plain error and the totality of the circumstances test, which is very important. Defendant seems to argue that if there's any improper expression of opinion, it's a per se constitutional violation that would result in reversing the conviction. However, if you have a per se fundamental error, then you really aren't applying a totality of the circumstances test. And all of the case law in this area requires applying a totality of the circumstances test. For example, Your Honors, in this case, it was a 3-day trial. The evidentiary phase of the trial was concluded on the second day, and that's when the court did its jury instructions. During the second day and the third day, there were jury instructions on assault on a female and habitual misdemeanor assault. The second day and the third day both included re-instruction of the jury. And while defendant is choosing excerpts and trying to isolate those comments out of its proper context, the state contends that this court must properly couch all of the court's statements within its proper context and analyze them with the entirety of the court's communication of the jury at issue. Excerpts or isolated portions of the jury instruction are not held to be prejudicial when the charge as a whole is correct, Your Honor. And that's out of State v. Young.
Let me jump in for a second here. Would you agree that the totality of the circumstances would include all of the instructions and all of the comments made by the court?
Absolutely, Your Honor.
Well, in the Court of Appeals opinion, there is, particularly in the dissent, a portion of the trial court's words to the jury are highlighted, but the facts of this case have demonstrated that there was actual contact. That's a touching of some form that was non-consensual and unwanted. Would you agree that that part I just quoted is an expression of opinion?
No, Your Honor. That is not an expression of opinion for the following reason. In State versus Young, in that case, the court said, the evidence tends to show that defendant confessed. If you find defendant made that confession, then then you should consider all the circumstances in determining whether that confession was truthful. In the similar way, in this case, the court said the facts have demonstrated that there was an unconsensual touching, or the facts have demonstrated XYZ. And the state contends that tending to show or demonstrating are analogous phrases. Just like in State v. Young, where this court said tends to show does not amount to an expression of opinion, this court should also find that using the phrase demonstrating does not rise to the level of expressing an improper opinion.
Well, I guess that for purposes of the analysis here, would you agree that the question is whether the statement of the trial court to the jury could lead them reasonably to infer that the court was expressing an opinion about what had actually been proved?
Your Honor, the state would contend the appropriate analysis here is one to determine whether there was an expression of an improper opinion, and then secondly, to determine whether that expression of an opinion was prejudicial to the defendant's case and caused the jury to reach its verdict.
But do you find it, does the state's position find it significant or of any import at all that the Court of Appeals majority, in describing its analysis as having considered the context, omitted that particular excerpt that I read to you?
No, Your Honor, because when you look at the case in its totality, when you look at the instructions in its totality, and you look at the Court of Appeals opinion, it's clear that the majority opinion did look at all of the instructions. While it may have only cited specific portions, in its analysis, it did indicate that they looked at the totality of the circumstances. That is because the court, the trial court that is, instructed the jury on assault on a female and then defined what assault was. They did that on the first day, the trial court did that on the first day of the trial. And then they the court re-instructed the jury on what assault was. And then pursuant to a request by the prosecution, on the next day, the trial court re-instructed the jury on assault and specified which allegations the jury was to consider when determining whether an assault occurred. In each instance, Your Honor, the trial court reiterated that the jury was not to rely on what the judge said. What the judge said was not evidence. The jury was not to rely on what the attorney said. The jury was to rely on its own recollections. The jury was to rely on its own determination of the facts, and that the jury ultimately was to determine whether the assault occurred. And so
is it your contention then that there could never be an expression of opinion by a trial court in the event that the trial court also says, in essence, and this is a hypothetical and not an attempt to describe the present record, but if the trial court said in effect in a homicide case, I believe that the defendant murdered the victim. However, it's up to you to decide that. Does the second statement preclude any possibility of an award of relief based upon the first?
The hypothetical that you're presenting, Your Honor, would be very difficult to mitigate. In that instance, Your Honor, the court is making a direct statement and saying to the jury, this person is guilty. This person has committed the homicide. And then later, just by saying, well, just disregard that. I'm just kidding. It's up for you. It's up to you to determine whether that happened. That is a different situation and a different fact pattern than what is before this court. Defendant isolated.
And the fact pattern that's before the court, at least, and this is my summarization of a fair amount of the language in the court's charge. The court said repeatedly something like, it's up to you to determine what the assault was or is. And that's in essence what Mr. Edgerton's argument seems to be that the trial court said. How is that not a statement that the trial court believed that an assault occurred?
When the court made its initial instruction on the second day of trial, the trial court specifically said, defendant assault, in order to prove assault on a female, the state must prove three things. that the defendant assaulted the victim and did so by hitting her multiple times about the face and head. You are the finders of fact. You determine what the assault was. The court is not telling you what it is. I'm just giving you a description. And then the court went on to describe another alleged behavior, that of forced fellatio, where defendant forced the victim to perform fellatio on him.
And in all fairness, the court later instructed the jury, I shouldn't have said that, and that's not part of what you should consider.
Absolutely. But it's important.
The court expressly instructed the jury not to consider that particular evidence and the court's, presumably the court's statement in deciding the defendant's guilt. The court never made a similar statement with respect to the comment about it's up to you to find what the assault was, right?
So that's correct, Your Honor, in the sense that when the court was using that terminology, you determine what the assault was. The state contends the reason that the judge made that statement is because he was presenting two different options. On the one hand, he was presenting the direct alleged behavior from the indictment, which was hitting her about the head and face. But the court also instructed the jury on this forced fellatio. Now, in that context, the judge was saying, you have to determine what the assault was. So this is what was, explained and testified to during the evidentiary phase of the trial. And you have to determine, was it this or was it that? And because the court was laying out two different options, the state contends that is why the court was saying, you determine which one it was. If you determined there was an assault, which one was it? You have to define what it was. Now, later, you're correct, Your Honor, that the court corrected itself and based on a request by prosecution said to the jury on the third day when it re-instructed the jury, it said, you are not to consider the forced fellatio. I shouldn't have said that. That was a mistake. You are only to consider the alleged behavior. Again, that is what the judge said to the jury. Don't consider the other act, just that it is alleged that she was hit about her body multiple times. And that's a direct quote coming out of the record. And so the trial court specifically told the jury that it was to disregard what the judge said and that it was to focus on the allegation, not the fact, but the allegation that she was hit about the head and the face multiple times, Your Honor. And that's why it was not an improper opinion.
Is it your position, and I want to make sure I understand your totality of the circumstances position, is it your position that the trial court did express an opinion, but that under the totality of the circumstances, the opinion did not rise to a level of prejudice? Or are you saying that in the totality of the circumstances, there was no opinion that was stated because the totality of the circumstances would obviate the fact that there was any opinion at all?
Your Honor, the state contends that there was no expression of an improper opinion. When you look at the totality of the circumstances, the entirety of the instructions given by the trial court, the state contends there was no expression of opinion. Bottom line. However, the state recognizes that this court may find that there was some error. The state understands here that these were not perfect instructions. However, perfection is not required by the law. The trial court is not a robot, and the law recognizes that there may be a need for clarification or the correction of certain jury instructions. In fact, North Carolina General Statutes 15A 1234 specifically allows additional instructions to correct and clarify the trial court's instructions.
What's your response to the other side's position that the repetition 5 times in number makes this present case unique from all of the other case law examples concerning what was stated, even if it was not an opinion?
Your Honor, I think in and of itself, repetition of a phrase could be relevant and could be important to this court's analysis in the case. However, here, the phrase that defendant contends was repeated, you determine what the assault was, is taken out of its proper context. And each time that the court was discussing assault or the definition of assault, the court used the appropriate couching phrases. For example, the court addressed each assault as an alleged assault or the alleged behavior. In each case, when the judge was talking about Claudia Little, he referred to her as the alleged victim or the prosecuting witness. So in each case where the judge said, you determine what the assault was, you are the finders of fact, each time the court also said, you are to rely on your own recollection of the facts. The law requires the judge to be impartial. You should not infer from anything I have said that the evidence is to be believed or disbelieved, whether a fact was proven or not proven. And this was reiterated at every point. Each time that the judge instructed the jury, defendant and prosecution had an opportunity to be heard. There was a brief bench conference, and then the court repeated itself and said and defined what an assault was. Defined that it would have to describe an improper touching and then describe what the allegations were. The judge was not saying these facts have been proven beyond a reasonable doubt. The judge specifically said that the jury had to determine whether the facts were proven beyond a reasonable doubt.
Can I ask you
repeatedly?
I'm sorry to interrupt, but I want to explore how the state is applying this totality of the circumstances concept, because and I'm glad you referenced the statutes, because 15A 1222 expressly says the judge may not express during any stage of the trial any opinion in the presence of the jury on any question of fact to be decided by the jury, full stop. And then 15A 1232 says again, in instructing the jury, the judge shall not express an opinion as to whether or not a fact has been proved and shall not be required to state, summarize, or recapitulate the evidence or to explain the application of the law to the evidence. And if we agree with the state that by issuing the standard jury instructions that say it's up to the jury to decide the facts of the case, that creates a totality of the circumstances that means there isn't an improper expression of opinion, aren't we essentially reading these two statutes out of the law?
No, Your Honor. The state finds that 1232 and 1222, those are compelling statutes and need to be adhered to. However, the case law indicates that when the court finds that those statutes have been violated, and if an error has been found, that's not the end of the analysis. You have to then look to see whether there's prejudicial error. And Your Honor, the totality of the circumstances portion is used not only to evaluate whether there was an error, but the court is also looking at the trial as a whole, the totality of the circumstances, and determining whether it was prejudicial error. And so, Your Honor, the state contends that you're using the totality of the circumstances at both levels of the analysis. And it's important with respect to the prejudicial analysis because as defendant contends that the state's case was weak. Now, this is not a sufficiency of the evidence argument. However, when you're looking at whether any error may be prejudicial or may have risen to the level of plain error, then the state's strength of the evidence is relevant. And I will turn to that point next, Your Honors, so that I can cover it. Essentially, if there was any error found, if this court were to find that using the phrases, you determine what the assault was, rose to the level so that a jury could infer that the judge felt like there was an assault, then, Your Honor, we would ask you to find that those statements were not prejudicial. Under the framework, the defendant has the burden to prove that a jury would not have convicted the defendant but for the erroneous instruction. It's the defendant's burden to show prejudice. Here, however, when you look at the state's evidence and you look at everything that the jury had to consider, a reasonable jury would have and could have convicted the defendant, regardless of whether they felt like the judge believed an assault actually occurred. The reason, Your Honor,
you just said that it was would have or could have. Is it, which is the standard in your view? It's possible that the jury would have convicted, or is it something else?
well, Your Honor, if you're applying the plain error review, then it's a probable standard. And then if you're applying the prejudicial review, it's the possible standard. Under either one, the state contends that the jury could have and would have convicted, regardless of what the judge said. Your Honor, that is because in its evidentiary phase, the state presented evidence that Claudette Little refused to go home with the defendant because she was afraid of the defendant. That was corroborated by her daughter's statements, and it was corroborated by Ms. Bonner's testimony, indicating that Ms. Little was truly in fear of the defendant harming her. There were also photographs taken the next day that documented the injuries that she sustained from the defendant. And both her daughter and Ms. Bonner's testimony substantially corroborated what Ms. Little testified to during the evidentiary phase of the trial. Now, defendant raises some red herrings, says because, law enforcement didn't testify, that must mean that law enforcement didn't stand behind that charge. That's an entirely speculative comment. There's no evidence at all that law enforcement didn't believe this assault occurred. And further, the prosecution has no duty to present every single photograph that was taken. The state decides how it's going to prosecute its case, and they chose the evidence they felt was most compelling. When you look at that, Your Honor, along with the fact that each time the judge instructed the jury on the assault charge, on the assault definition, on assault on a female, the judge reiterated that the jury is the finder of fact. The jury is to determine what evidence they're going to believe or not believe. The jury is to determine what weight to give the evidence. And the jury is to determine whether all of that evidence presented by the state was sufficient to prove beyond a reasonable doubt that the defendant in fact assaulted Ms. Little, that he caused physical injury, and that he was guilty of assault on a female. Now, because the standard of review is plain error or even prejudicial error, and because in the totality of the circumstances, the state contends that there was no improper expression of an opinion, we respectfully request that you affirm the Court of Opinion's decision and uphold defendant's conviction. Thank you.
Thank you, counsel. Rebuttal.
Mr. Edgerton, you're muted.
Sorry. First of all, I'd like to note that the state emphasized the importance of totality of circumstances review. Defendant 100% agrees. Well, only the dissent addressed the totality of the circumstances in this case. The majority omitted consideration of key evidence, and this goes to the questions that Justice Hudson and Justice Earls asked. Defendant respectfully submits that the majority opinion did not follow the law. It was supposed to consider the totality of the circumstances, and it plainly did not. It's hard to read its intentional omission of the most crucial evidence the defense has from its opinion as anything other than we're not considering this. I think that message was pretty clear, and I think that message is a very clear indication that the majority did not consider the totality of the circumstances. And the totality of the circumstances that it left out was the evidence that most strongly contradicted its holding. I think that speaks for itself. Number two, the state conceded that defendant's hypo was difficult to mitigate. Again, we 100% agree. That hypo is pretty much a summary of what happened in this case. The trial court told the jury multiple times, intimated multiple times, and at one time, in fact, told the jury, but intimated multiple times that an assault had occurred. And then the response in the Court of Appeals majority is, well, that doesn't matter because he didn't tell the jury that they had to find an assault. I went over this in great detail, that these are two totally different questions. And the majority failed to rely on the proper question in this case, which means the majority failed to properly apply the law. And then also the state talks about the mitigating stuff. Defendant respectfully responds, what jury is going to simply ignore the fact the trial court told it 5 times over multiple days, or intimated 5 times over multiple days, that an assault occurred? When you get back in the jury room, you can't unring that bell. They have heard it over and over again from the trial court. And the fact that the trial court at the beginning of instructions said it's up to you to decide whether a defendant is guilty of assault on a female. This is actually something the state cites as mitigating evidence. The fact that at the beginning of the instructions, the trial court said something that had nothing to do with the case. Whether the defendant was ultimately going to reach it was up to the jury to decide whether the evidence supported finding the defendant guilty of assault on a female. That is not the same question presented here. That is talking about defendant's right to a trial by jury. We're talking about, can the jury reasonably infer from the evidence that the trial court intimated an opinion? I don't think that's debatable here. I mean, how many times does the trial court have to say it? So the repetition matters. All right.
Mr. Edgerton, I'm sorry to interrupt you, but you emphasized the importance of repetition in the statements of the trial court as having been significant.
Yes.
Do you also agree that repetition of the sort of reaffirmation to the jury that they're the ones who decide what the facts are is important?
Well, first of all, if you look at all the instances where that happened, it's less than 5. Second of all, I would agree that if the trial court were actually mitigating what it said with these statements, it could factor in. But again, the trial court saying it's up to the jury to decide whether a defendant is guilty of assault on a female is not the same thing as the trial court saying what I said earlier is wrong. And they got into this a little bit. Well, I only have a little bit of time left, so let me finish with this. The bottom line here is the dissent properly followed the law applicable to this case. Only the dissent followed the trial court's guidance from Lattimore in reaching its decision. Thus, only the dissent correctly considered the totality of the circumstances. Only the dissent followed this court's guidance from Blackenstock and Yellerday in reaching its decision. Thus, only the dissent applied the correct framework of analysis. Defendant urges this court not to put its stamp of approval on opinion it knows to be flawed in both application of the law and acknowledgement of the facts. Defendant urges this court to adopt the dissent.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court.
Thank you.
Thank you, counsel.
Very, very strong argument.